factual, and timely. Welcome back. Thank you so much for staying with Look Up TV. Nancy Nalima here, and now joining me is Advocate Annette Kwamboka. Karibu sana. And you're not a new face here, so you feel like home already.
But it's always good to be here. Thank you for having me.
Karibu sana. And of course, we want to make people understand the Constitution. Yes. That it's just not this book that is for learned friends.
Yes, the Constitution is a document for every single citizen.
Right.
Yes.
So we should be able to understand it, even the layman, mwananchi wa kawaida, right down the streets, because this is the law.
That was the intention behind drafting the Constitution, to make it as palatable as possible to every citizen.
Right. And of course, this week we're taking a look at ADR, which is Alternative Dispute Resolution.
Yes.
So other than the formal way of dealing with disputes, then there are alternatives to it. And I do understand we we took to the streets just to get to understand what Kenyans understand about the Constitution, of course, specifically the alternative dispute resolutions. Do we have that, Director? But we'll be taking a look at that in just a short while. And so, Annette, let's just jump straight into our conversation. So when we talk about the alternative dispute resolution, it's obviously an alternative, but just break it down for us to understand.
So alternative dispute resolution refers to other mechanisms of resolving disputes away from a formal judicial setting, and that means the court system as provided under the Constitution. So we have three principal forms of alternative dispute resolution. We have arbitration, we have mediation, and we have reconciliation, as set out under Article 159 of the Constitution.
And before we get into that,
yes,
ideally we're talking about resolving conflicts and disputes. So let's just, if we can take a look at how historically, perhaps, in the past, our grandfathers, how conflicts used to be resolved, because there were no courts at the time.
Yes. Long before colonialism, right, we had a society, we had different societies existing in Africa and in Kenya. And the truth is, we had structure. It may not be what it is today, but we had structure when it came to leadership, when it came to religion, when it came to societal norms, when it came to different cultural norms. We had systems, we had leaders, and we had different players in these structures. Yeah. So we used to have the Council of Elders, for example, who would be drawn from older people in a society who have experienced life in itself in such a way that then they will be able to provide direction to members of a community on how certain things should happen, and that included resolution of disputes. But you have to remember, Nelima, that this is a long time ago, and there were certain societal and cultural attitudes towards different sections of the community, for example, women. And you would find that this dispute resolution mechanisms really didn't acknowledge perhaps equality of women and men. Right. And even when it comes to rights of owning property, that women and men have equal rights to own property and to dispose of it in any way that they wish. So you would find that there were certain aspects of traditional dispute resolution that would be considered in this day to be repugnant to the Bill of Rights, natural rights of people, and would be contravening constitutional provisions. Yeah. But in itself, there was a system. It wasn't entirely a bad system, but it had different cons.
Okay, and I understand now we have the video. Director, if you can just give us a take on what Kenyans think about alternative dispute resolutions.
Nitaenda police station kwanza. That's the nearest thing.
Na unajua kuna kitu inaitwa alternative dispute resolution?
Najua.
Unaelewa nini kuhusu?
Okay, hii resolution ni as in, kama najua exactly mwenye amechukua hiyo kitu yangu, tuseme maybe niko na evidence, najua ni huyu amechukua, naweza contact the mtu mwenye maybe ako karibu na yeye, ama ako karibu na mimi, nimwambie, nimwelezee, then tuende tuongeleshe huyu mtu mwenye amechukua mi property yangu, tumuongeleshe, tumuone kama alichukua ama kuchukua.
First thing naomba kwanza, then naenda na report kama kuna authorities. Naweza pia share kwa mabeshte. Pia naweza enda church nieleze mchungaji.
Nina report. Sasa nikireport ndio nianze process. Yeah.
Na unajua kuna kitu inaitwa alternative dispute resolution?
Sijajua.
Maybe kwanza ndaenda kuripoti kwa polisi. Yeah, ama kwa chief kwanza, and then anipatie ile vile naweza enda kwa kuripoti kwa polisi. Lakini kama ni shida nyingine pengine ndauliza one of the family members, and then tuongee kwanza, and then nione vile kutakuwa.
Mimi kitu yenye naweza fanya ni hivi, kama ni majamaa wenye tumezaliwa na mama mmoja, tutafute mkuu wetu atupe guidance na kazele, alafu after that tujadiliane na wao to solve your problem.
Unajua kuna kitu inaitwa alternative dispute resolution?
Hiyo bado kujua.
Right, and those are Kenyans with their diverse opinions. And of course, Annette, as you can hear, maybe the term alternative dispute resolution may seem unfamiliar, but from what we've heard, some said they report to the police. There's one person who said, Anenda kwa mchungaji, so which is the pastor in church. Someone said, go to the chief. And another person said, sit down and try to see if they can figure it out. So there's some understanding of alternative dispute resolution. Maybe they just don't know it's an alternative dispute resolution.
What I can say, watching those Kenyans, I get the sense that some of them resonate with the concept of alternative dispute resolution. Right. But then I have to point out different aspects of conflict resolution interpersonally between people when it comes to conflicts that arise every day, because this is a work setting. You may sometimes disagree with a colleague. I at work may sometimes disagree with a colleague, but we have this interpersonal framework of how we can resolve a conflict. And that is where you see, for example, if it's two brothers fighting, they'll go to their mother or they'll go to an older person in the family to give them directives. But then we have conflict when it comes to now principal or serious legal issues, for example land disputes, and even things such as rape and murder, and how alternative dispute resolution then relates to such things. So for example, one lady says if someone stole her item, she will look for someone close to that person and then go and confront that person or find mutual friends to try and resolve that issue. And you see, this is a criminal case, and when it comes to the prosecution of criminal cases, these are matters of public interest, and that is why state prosecutors are the ones who prosecute this on behalf of the state. It's usually the republic versus the criminal, at least until a point where they're proven guilty or innocent. So the Constitution in itself under Article 159 is clear that alternative dispute resolution mechanisms can be used to the extent that they are not repugnant to the provisions of the Constitution.
And what exactly do you mean by repugnant?
And that, meaning that they're applied in a way that is contrary to the rights given to citizens under the Constitution. Right. So I usually see, for example, sometimes things like marital disputes involving serious violence against most of the time a woman being resolved within the family, and she has a broken leg, she has a broken arm, and they're before elders in the family trying to resolve this. But this woman was assaulted. The best way to deal with such a situation, you know, we really don't know what will happen to her within that marriage, but we know that under the penal code there are certain prescriptions that have been, there are certain provisions that have been given, and a sentence that has been given to a person who's found guilty of assaulting someone else physically in this case. So when you resolve that, let's say through reconciliation, but in the Bill of Rights under the Constitution, every person has a right to be free and right to be treated well without any, and right to be treated in a way that free from any form of cruelty. And then every person has that right to freedom, not to be limited, to be able to move from one place to another. Right. So when you think about these women in these situations where some of these things are resolved through reconciliation or informally within family settings or filial settings, and the truth is these are serious criminal cases that are repugnant to the rights of this woman under the Bill of Rights. That is what we call repugnant.
Okay.
Yes.
And so all cases, you've talked about criminal cases.
Yes.
But so it's not all cases that can be handled under the alternative dispute resolution.
You see, when you look at a dispute arises, for example, where people have a relationship or where there's an agreement in place,
Right.
and one of the parties feels aggrieved either because the other party hasn't kept or rather hasn't performed the obligations as earlier agreed. It could be a contract for the provision of services, it could be a contract for the sale of land, and then it could come to things as, for example, an agreement for the supply of services or the supply of, for example, goods to a business and things like that. You look at the nature of the dispute, and then it's in the interest of the parties when they want to determine what form of dispute resolution they want to go to. You first of all look at how much money you are willing to spend in terms of resolving this dispute. You look at the amenability of both parties to arrive at a solution, and you also want to find the quickest way to arrive at a resolution to this particular dispute. And therefore that determines, it's not only in criminal settings, but there are also forms of alternative dispute resolutions for transactional matters.
Right. And allow me to quote a case as I was looking at the ADR, and it's a case which happened sometime in 2011. I'll just read it through. It was a criminal case 86 of 2011, where Mohammed Abdul Mohammed was charged with the murder of Osman Ali Abdi, and on the date of the hearing, the deceased family withdrew the charge on account of a settlement reached between the families of the accused and the deceased respectively. So this was a murder charge, and the families decided to resolve within themselves. And of course, it is a case that raised a lot of reaction from people. And you had mentioned that a criminal case can be different.
Yes, so I remember that particular case in 2011, and I remember at that time I was in my first year in university, and we discussed the modalities of that case in our criminal law class, which used to be a foundational class in the old curriculum as it then was for a first year student. Right. But you see, and what was paid in that specific case, if you read the particulars of that case, that exchange of money, it was referred to as blood money, which usually exists in various communities, where, for example, a person is murdered and reparations are paid to the deceased murdered person's family in the form of money to placate them and tell them sorry for what happened. Right. But you see, this is a matter, a murder of a person is a capital offense. And when a person has murdered another person, the state then becomes involved, because it's possible that this person could also murder another person. When it comes to murder, it goes beyond the person who's been murdered and their family. It's a matter of public interest. And one of the criticisms of then having these two families withdraw the case and say we have settled it is that that act of the accused person in murdering the other person contravened that right to existence and to life under the Constitution. Right. That we then have. And then again, that takes us to the issue of being repugnant. And does that then set a precedent for other situations where persons are killed and the matter is settled culturally? I would like to address a report and a study that has been done in various hotspot areas where we have 2 or 3 communities in Kenya, for example, coexisting in one area, and they share resources. And in these communities, especially where mass killings happen, for example, in the Mount Elgon area, it has been seen that most of the families resorted to, or naturally those communities resorted to, reconciliation meeting, payment of cattle, doing cultural rites to appease the other community and to settle that matter. And again, it seemed to be the preferred choice of the persons affected there, because nothing will bring back my brother, my son, or my daughter. But if I'm paid or if I'm given cattle, it placates. It's a sense of convenience, right, rather.
So it means that if I'm aggrieved, then it is upon me to file charges formally the police or not, so that if I don't, then nothing can be done.
Well, we know that for a criminal case to happen, a report has to be given. It doesn't necessarily have to be by the person who's aggrieved, etc., because it's a public interest issue. If I see someone stealing or if I see someone assaulting someone else, I can report it. So it doesn't necessarily have to be the person who has been affected.
Okay.
But what I'm alluding to is that in some communities, despite the fact that we want the formal process because it's a public interest issue, especially in a criminal case, and we want a matter to be prosecuted to the end, in some communities, studies have shown that these communities sometimes prefer the traditional forms of dispute resolution because it's quick, it seems to placate them, and then it matches their cultural beliefs, etc. So there are a lot of studies, especially I know the Kenya Law Reform Commission has really been looking into how to inculcate some of these things into the current formal forms of dispute resolution in such a way then that they create a threshold to determine what is repugnant to the provisions of the Constitution and what is not. So I'll give an example of another hotspot area, Borabu Sotik. This is where Kisii and Kipsigis have coexisted for so many years. And then the land question, especially in areas like Kisii, has spanned decades. And you remember after colonialism ended around independence, there was the consolidation of land, and then after that there was the adjudication. So there's a lot of adjudication of land in areas like Borabu, what we call settlement schemes, and there were a lot of disputes over whether this land belonged to the Kipsigis or whether it belonged to the Kisii. Then another issue in that area was cattle rustling, but we saw that the local authorities and also offices like the DEO, the DC from the different districts as they then were would come together and try and hold peace meetings that even happen still today between the two communities to sort of find a way of reconciling them. Right. So it depends on the nature. For example, in in Mount Elgon, it was murder, it was mass killings of people. That is different. But when it comes to Borabu Sotik, it's cattle rustling every now and then, and each community being a nuisance to the other. That can be resolved through traditional forms or alternative forms of dispute resolution, like the citizens mentioned, DO, DCs and
so
chiefs.
From what I gather, then it's just it depends with the gravity of the case.
It depends on whether it's repugnant to the provisions of the Constitution.
Okay.
Yes.
And therefore, someone may ask, can the alternative dispute resolution, of course, help the current cases in court? Because as we know, the judiciary, there has been a lot of backlog of cases.
Yes.
And we've seen even the alternative justice system being launched by Chief Justice Martha Koome. But now, to what extent? Because it can't take all the cases.
Indeed, alternative dispute resolution, especially arbitration and mediation, has really eased the backlog of cases in the judiciary. Our judiciary has seen from time to time demonstrated that it respects the place of alternative dispute resolution in resolving disputes between parties, especially where in transactional matters where there's an arbitration clause and it's set out in that contract that if the parties should disagree and a dispute should arise, the first cause of dispute resolution will be arbitration. So if one of the parties then rushes to court before the matter is decided or referred to arbitration, the court will look at the contract and say there's an arbitration clause over here and we will refer you to the appropriate arbitration channels and mechanisms for this dispute to be resolved before it's then heard by or before it's considered as a matter in court.
Right. And so while the alternative dispute resolutions helps even with the cases, the backlog of cases, then what is the downside?
Well, some forms of alternative dispute resolution can be very expensive. So the opinions that you got were from citizenry, but there are more sophisticated forms of disputes, especially where it comes to contracts of very, very high value that span a long period of time, and the risk is very high. And then in such contracts, or in such commercial settings, it's very easy for parties to disagree, etc. And such parties can actually afford arbitration costs because you have to get professionals. You have to get certified arbitrators who've gone through the requisite curriculum and are acknowledged by our own branch, the CIAB, Chartered Institute of Arbitrators, the Kenyan
branch. So there
branch.
are certified arbitrators?
Yes. And they're certified mediators as well in Kenya. So what the citizens were referring to in the information you collected, those are informal forms of conflict resolution. Right. But dispute resolution, we actually have professionals who then are trained to arbitrate or to resolve disputes within an arbitration setting or within a mediation setting. And with having professionals then come costs. So arbitration sometimes can be very costly, and it's very sophisticated parties, like for example commercial entities or people who have the money to pay arbitrators to resolve the cases. So cost is one thing, and not everyone can afford it.
So alternative dispute resolution is not cheaper than a formal case in court?
Not necessarily. Sometimes it may actually be more cost effective to pursue a matter in court than to refer to it to arbitration. So when it comes to arbitration, you first like I said, you first have to look at the contractual agreement between the parties. Then you have to look at the nature of the dispute. Sometimes, example, if it's a matter of construction, a judge may not be well versed when it comes to matters of construction, but an architect, a surveyor, such people have the requisite knowledge. So for example, we have architects who are trained to be arbitrators. We have surveyors. Anyone can actually train to be an arbitrator in a specific professional field, right, because they have the specific knowledge. So over there it would be best to pursue arbitration.
I can train to be a professional arbitrator?
Yes, you can. Okay. Yes, you can. Mm-hmm. So but for example, when it comes to matters, simple contracts. For example, if you and I have an agreement and I'm supplying goods to your company, and what I owe you is, for example, in our account, you owe me 50,000 shillings that you haven't paid. It won't make sense for me to refer that matter to arbitration and get professionals to actually determine it. We may end up spending in terms of legal costs more than what I'm even claiming. Right. But now we have the small claims court, whose threshold is disputes below 1 million shillings that then can be determined easily. So such a matter can be determined to a small claims court. The legal fees that you pay will be a lot less than what you pay in arbitration. So arbitration and alternative dispute resolution sometimes is not the easiest option, the cheapest option.
That is good to know. And of course, very informative even to the general public. And I understand that our time is up, but before that, maybe because conflict is inevitable, so just how to resolve conflict is now what we need to master. So what would your sentiments, your last sentiments be on how to resolve conflicts, just in, say, organizations or one-on-one with different people?
So I will address myself to conflict resolution in 3 settings: institutionally, as you've mentioned, then contractually, and then interpersonally. Right. So institutionally, it is good to have policies addressing certain things or areas of conflict that may arise. For example, sexual harassment, and the Employment Act requires that where you have employed more than 20 employees, you have to have a sexual harassment policy, enabling people to report, enabling disciplinary action to be taken, etc. So for institutions, I would say come up with policies on hot button issues of conflict that may arise between parties. Then when it comes to contracts, I will say safeguard yourself. Look at the nature of the contractual relationship you're entering into, and then get the requisite advice on what the most appropriate form of dispute resolution would be. Then interpersonally, I will say this comes with time, it comes with growth, emotional intelligence, and interacting with different people. You build capacity as an individual on how to resolve conflict with another person. Read, and then always seek to understand and find methods of resolving conflicts between you and another person.
Right. And thank you so much. That is Advocate Annette Kwamboka giving us a wealth of knowledge on matters alternative dispute resolution. And I think the word of the day is repugnant. Like, you need to read it more. And of course, we'll be looking at different big words from the learned friends and just try to break it down for people so they can be able to understand the Constitution bit by bit, because it involves us. It is the law of the land, and so it is of our benefit that we get to understand it to the very beat, to the end of it. Yeah. And thank you so much, Annette. That is where we conclude the insight tonight on our segment, My Constitution. We'll be talking about alternative dispute resolutions. Keep engaging with us across our social media platforms at Lookup TV on Twitter, Lookup TV on Facebook, and Lookup TV on our YouTube channel. I am Nancy Nalima. Our sign language interpreter for tonight has been Josephine Oko. And join me again next week for My Constitution. Have yourselves a pleasant evening. Good night. factual and timely.